When a prosecutor seeks to elicit evidence the defendant committed a prior bad act or crime, what standard of proof must be established that the defendant was the perpetrator of that prior bad act or crime? To find out, you have to read People versus Robinson, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Robinson. This is a landmark case, part of a limited series I'm doing on landmark cases from the New York Court of Appeals, published by the New York Court of Appeals on December 18th of 1986. The citation for this case is 68 New York 2nd, 541. The issue in this case is in a Molineux hearing where a prosecutor is trying to establish the defendant committed prior bad acts or committed prior crimes. By what standard of proof must it be established that the defendant was the person who was the perpetrator of the prior bad act and crime? To understand and appreciate the background of this case, I think the background that's helpful to know is that in the United States of America, you can only be convicted of a crime if and only if the prosecution has established your guilt beyond a reasonable doubt based upon evidence about the crime that you're accused of. You're not really allowed, generally, there's a general prohibition on introducing prior bad act evidence because there's a risk that the jury could convict you because you're a bad person or you've done bad things, not because you're guilty of the crime that you're accused of doing in this occasion. Imagine if a person committed 25 previous assaults and is accused of assault here. The jury could just convict him of assault because he committed 25 previous assaults, even if he's actually innocent of this and not guilty of this particular charged assault. There's a case called People versus Molineux from 1901. It's a landmark case that I made a video about that's in the channel. And that case says that in certain circumstances, in limited circumstances, a prosecutor will be allowed to introduce evidence of prior bad acts or prior crimes. And the mnemonic that we all learn to when those circumstances are, it's a non-exhaustive list, but the general guidelines are MIMIC, M-I-M-I-C, which is motive, identity, mistake or absence of mistake, intent, and common plan or scheme. And the last thing that I think is helpful to know is that in New York, there are several different standards of proof, burdens of proof, or standards of proof, and those standards are preponderance of the evidence, which is basically more likely than not. Another one is clear and convincing evidence, which is higher than preponderance of the evidence. And the last one is beyond a reasonable doubt, which is the highest standard we have, and it's the standard that we use in criminal conviction area. What are the facts of this case? The facts are that the trial in this matter is about attempted bank robbery. It's alleged in the accusatory instrument, in the felony complaint here, in the indictment, that on December 12th, 1978, there was an attempted bank robbery in Albany, New York. In that attempted bank robbery, it's alleged that a man walked into the Central Avenue branch of the Home Savings Bank in Albany, New York, handed a large manila envelope to the teller, whose name is Miss Piney, which had a note on it. That note stated, in quotes, "This is a holdup. Your life is in danger. Put 100s, 50s, 20s in a bag. Keep hands in sight at all times." The teller then said to the man, "What is this? What do you want me to do?" The man got nervous, turned around, and left. A customer observed this. Neither Miss Piney nor the customer were able to identify the defendant at trial as the person who handed the note. At that point, the prosecutor said to the judge, "I want to introduce Molineux evidence. I want to introduce prior bad act evidence that the defendant committed 1 week earlier, 7 days earlier, a completed bank robbery in the same area of Albany." And the judge said, this is to establish identity, that the defendant was the person who committed this offense. The judge allowed the testimony under Molineux. And at that point, the prosecution then called witnesses from the previous completed bank robbery. He called the teller, who testified that a man walked in, handed her an envelope that had the following things written on it. "This is a holdup. Your life is in danger. Put 100s, 50s, and 20s in a bag. Remain calm for your own safety." The teller then handed the person money, and he left. Neither incident had sufficient surveillance video. They were both blurry, couldn't make a positive identification. Then the prosecution called a witness, a handwriting expert, to say the handwriting on the two notes from the attempted bank robbery and the completed bank robbery matches the handwriting of the defendant's application to go to SUNY Albany, where he was a student. At that point, the case went to the jury. The jury convicted the defendant of attempted robbery in the third degree, and the defendant appealed, saying improper use of prior bad act testimony. The appellate division affirmed, the procedural history is appellate division affirmed the conviction, finding that identity was a crucial issue, and the conduct of the two crimes was sufficiently unique to permit proof of the uncharged crime to establish guilt of the charged crime. The defendant then appealed to the Court of Appeals. And here, the Court of Appeals goes through the Molineux rule, but clarified that with respect to identity as the exception, there's a specific burden of proof. There's a standard of proof to which must be applied with respect to whether the defendant committed the prior bad act. And they say, this is a novel question that's not been answered. To what degree must the defendant's identity as the perpetrator of the uncharged crime be established in order to make proof of it admissible? And they say that different jurisdictions have handled this differently, using preponderance of the evidence, clear and convincing evidence, or beyond reasonable doubt. And the holding here is a trial judge who admits evidence of an uncharged crime on the issue of identity with less than clear and convincing evidence of both a unique MO, modus operandi, and identity of the defendant as perpetrator of the crime abuses his discretion as a matter of law. So the floor here, the floor is clear and convincing evidence. It must be at least clear and convincing evidence that the defendant committed the prior bad act and that it's an MO if it's for the sake of identity as the exception. And here, applying that standard, that new rule, the judge did not have clear and convincing evidence that the defendant committed that prior bank robbery, and therefore abusive discretion, conviction reversed, new trial ordered. And that's the case of People versus Robinson. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.